Good morning. How is everybody today? So do we got to do two? First of all, you do know you're clapping for a lawyer, right? Okay. So a little bit about me. My name is David Sanders. I've been practicing law in the state of Nevada for about 17 years now. Before I came to work with the realtors, I represented clients such as Freddie Mac, Fannie Mae, Bank of America, JP Morgan Chase, the FDIC, and the Department of Treasury in real estate and mortgage-related litigation throughout the state, and up through and including the Ninth Circuit Court of Appeals. I've been with the realtors for about 6 years now. In Las Vegas, and that's a little bit about me. So today we're going to be talking about a lot of forms. We're going to take it very slow because there's a lot of information. We will take breaks. I realize that you may actually have to go out and, I don't know, sell real estate to keep the lights on. So if you have appointments and you need to step in and out, please feel free to come back, jump in. We're going to just walk through the RPA and all of the related forms to the purchase agreement today. Tomorrow will be the buyer brokerage agreement, the listing agreement, and I want to take a few minutes to talk about the wire fraud disclosure because I think it's really going to be helpful to protect you from that growing issue that we're seeing nationwide with wire fraud and unfortunately the growing trend where the buyer turns out to sue all the realtors involved rather than the bad guys who took the money. So we'll talk about that tomorrow. Questions. Unlike most people, I do believe that there are stupid questions, and I'm going to tell you the two stupid questions right now. Number one, you call the Internal Revenue Service and say, isn't it about time you audit me? That's stupid question number one. Stupid question number two is you've been pulled over by the Highway Patrol and the officer says, I'm going to let you off with a warning, and you say, is it in fact ethical for you, officer, to let me off with a warning when I was in fact speeding? Beyond those two questions, anything is okay. So we are recording this, so when you ask your question, I'll repeat it back to make sure, one, that I understand, and two, that the folks at home will understand as well. So we're going to go over just forms today. I am not an expert in Transaction Desk. I do know Transaction Desk has phenomenal tutorials and videos on their website, so feel free to check those things out. So we're going to start off, the first form is the residential purchase timeline and checklist. Now, I like to start off with this form because I was a litigator for about 15 years. And as you know, in litigation, there are deadlines, there are timelines. And so on the outside of every one of my litigation files, I had a checklist and a deadline. So I could tell exactly when things were due. So that's what this form does for the RPA. If you'll notice, you have your client, the address, the close of escrow, and on this side you have the dates, and it'll tell you whether it's business or calendar. It also tells you the event, and it references the section of the RPA, so that if you're a broker, or if you're a team leader, or if you're just killing it, you got lots and lots of files, you can be able to tell quickly from just this form, if you fill it out, to walk through what your options are. So with that, so that's there. So I want to jump now just right in. Does anybody have any questions before we start? Yes. All these forms will be available in Instanet. I prefer to show them to you in a PDF so that we can talk about the actual form. But all these are available in Transaction Desk and have been for how long? A little bit?
10 days.
About 10 days. So this one's called Residential Purchase Timeline and Checklist. Okay? So just to be clear, Transaction Desk is a separate system from ZipForms. We've been using it in Las Vegas for about 4 or 5 years, and we really like it. They're really quickly on turnarounds for updates, and we haven't had a whole lot of complaints from our membership. So while they're figuring this out, I wanted to talk to you really quickly about the purchase agreement. When we decided to change the RPA in Las Vegas. This was about a 2.5-year project. If you're ever in Las Vegas and you want to come over by my office, I will show you my collection of purchase agreements that are in use west of the Mississippi in every jurisdiction because I have no life. But we went ahead and we looked at every other, we looked at California, we looked at Utah, we looked at Arizona, we looked at Colorado, Oregon, Washington, and we looked around at every other jurisdiction and said, you know, what do we like about their documents so that we could make what we thought was the best purchase agreement? And I'll be honest, this all started totally selfish. I bought a house, and it was a terrible contract. It was a terrible experience. I signed everything like everybody else with this, right? I didn't actually use a pen, and it was difficult to actually view everything. So this document's actually been, the RPA has been designed to be executed electronically. It's designed to work in Transaction Desk, and also if you're old school and want to print it out, we've got you that covered as well. The other thing we really did is we brought in a group of 20 practitioners, some of our top producers, and we set them in a room and we took every section of the document and we blew it up on a 1x3 foot piece of paper, and I said, let's put the document together in the logical order. I know, novel concept. In the logical order that you would explain it to a buyer or a seller. And so that's what we did. So the first thing is we talk about the property, then we go into financing, and we explain what the due diligence section is. We do all of that in a logical, linear fashion. So it's designed so that when you go into that buyer presentation or that seller presentation, you can just take the form and walk through it and answer all those questions in a logical fashion. So let's do this. Let's go right into the RPA, and I will read it off of the screen. So this, again, I don't need to take a whole lot of time looking at the timeline. Dig it up on your own time. You don't have to use it, but if you're looking for a quick, easy way to verify all the deadlines in all the sections so you know what your potential liability is and when things are due, you can certainly do that. So if you'll notice over here, again, back to this document, you've got business days, calendar days. So if it's a hard deadline that's established in the contract, you'll see it there. If not, you'll have a section where you'll need to fill it out. And it also, for example, here, title company provide preliminary title report. It tells you the section of the RPA, 8C in that scenario. So you'll know exactly what those are. Okay. So this is the purchase agreement. The top is the title's cut off, but everything else is there. So it leads off with residential purchase agreement. So you're going to start off with the buyer, the date, property, city, county, zip, APN, purchase price, and then buyer does or does not intend to occupy the property. Okay, and so let's talk earnest money. So earnest money is either presented or will be delivered. Now, state statute indicates that earnest money has to be deposited either within 1 business day after acceptance or if the parties agree otherwise. So that's what this blank line is right here, or business days if wired, and you've got identified to the escrow holder, buyer broker's trust account, or the seller's trust account, with the disclosure that it's a felony to, cut a check that you don't have funds to cover. There is a separate standalone earnest money receipt. We spun it off outside of the purchase agreement for the following reason. A realtor in Las Vegas got dinged in front of the real estate division for signing an earnest money receipt and actually not receiving earnest money. So it's a standalone document that you will only need to use if I walk into your office with a bag full of cash and say, here's my earnest money. Okay, any questions about that? Because what had happened is because it was part of the document, the realtor's compliance department required them to sign it. The member of the public filed a complaint, and they got a several $1,000 fine in front of the division. And I don't know about you, but the division does a bang up job on their own. We don't need to help them finding ways to get you potentially in trouble. So we spun that off. So that earnest money, we'll show it to you. The idea is we're going to go through the entire purchase agreement, and that's going to take some time. And then we'll do all the side standalone documents as well. So earnest money receipt. Now, I do want to say one thing about the deposited with 1 business day, or because, and I don't know if you guys work late at night, but acceptance in this contract in section 25 is the definition section. So section 25 defines acceptance as the time that both the buyer and the seller not only sign the document, but they've also received an executed copy. So let's walk through the following hypothetical. You send me an offer. Both parties accept it. I like to work late at night, so I send it to you. You forward it to your clients at 3 o'clock in the morning. If we don't have the change, it says we have to have the earnest money deposited within 1 business day. If acceptance occurs at 3 o'clock in the morning today, when is the next business day? It's today. See what I'm saying? So if you accept at 3 o'clock in the morning,
3 a.m.
Yes, but the next business day pursuant to state law starts at 9 o'clock. See what I'm saying? It's an unintended consequence. So if you work late at night, and I'm not suggesting that you shouldn't work late at night, if you work late at night, be mindful of the fact that you may be unintentionally walking into a problem and taking away 1 to 2 business days. So just be careful with that because of the way we define acceptance is when everybody gets it, which is a good idea, and the way the state defines what a business day is, okay? Don't think this is going to be a major problem, but it's come up in Vegas enough that I wanted to make sure that we talked about it because I'm sure you guys are all hard workers and love to be up at 3 o'clock in the morning accepting offers like me. So, okay, additional deposit section with the language about whether or not it'll be considered part of the EMD. And it says any conditions on the additional deposit should be set forth in Section 28. Section 28 is the additional terms section we'll get to in a minute. And then we've got contingent upon qualifying for a new loan with identifying what the loan is, contingent upon whether or not there's an assumption of the existing loan. And then if you'll notice here, we have this sentence, seller further agrees to provide the promissory note and the most recent monthly statement of all loans to be assumed by the buyer within 5 calendar days of acceptance, 5 calendar days, if there's going to be an acceptance. Promissory note, execution, balance of the purchase price and good funds to be paid by the close of escrow, and then the total purchase price. And that's the first page of the RPA. Now this RPA is less than 10 pages for you Harry Potter fans. It's literally 9 3/4. You're welcome for that. I have a 15-year-old daughter. She got really excited about that. So that's the first page. Are there any questions about this page so far? Line 34. Okay. This is owner carry financing. So if the situation is the owner's going to carry it, they're going to need to be an executed promissory note. Okay? Anybody questions on that one? Owner carry? I don't know if that happens much up here, but if it does, if you do owner carry for your own personal sake, make sure you have your clients go talk to an attorney. With the changes in Dodd-Frank, I'll get you in just a second, there's a lot of potential liability out here for you if you actually do this. I won't touch it, and I've been practicing law for about 18 years. Yes, sir. Yeah, so I'm sorry, this is a problem when we convert the forms out to, the forms are designed to work well in Transaction Desk. They're not designed to work well in the PDF. These are actually going to be just lines where you would make a checkbox. And the why, it does this PDF thing, but what we've done is for the brokers in the room, whenever there's a section that you have to answer, Transaction Desk will not allow your agents to go beyond that. So there will be there's not an ability to leave blanks in the document. And that, unfortunately, is just a formatting error when we transition over to the PDF because we sit down with the software developers with Transaction Desk and we do a beta test about 60 to 90 days before the forms go live to work out all the kinks to make sure all the information that's being transferred over is accurate. And that is an unfortunate side effect. But thank you for pointing that out. Yes. The next page is where we do cash offer. Yep. And hold on. Here's the cash purchase. We just haven't got to it. It's on page 2. So what you're going to do is so the question is if there's wiring instructions and we're going to wire it, how do we address it in the form? And what the form does, if you look up in here, it's lines, I think 16 and 17, or X number of business days, so you pick 2, 3, 5, whatever you need to be wired to, and then you'll identify the escrow holder, which we define later on in the contract, the buyer broker's trust account or the seller's broker's trust account. So there's the ability to identify it, and then once the contract is executed, then you can go to the escrow company, and then they will issue the wiring instructions. Because again, with wire fraud and those issues, we decided to do it this way, so that if there's problems with the wiring instructions, it's all on the escrow company. I like to joke that I'm the realtor's attorney, so I have no problems throwing title and mortgage under the bus as long as we protect you guys. So that's why we did it that way. All right, page 2. Is there a way we're missing the first top of the first paragraph?
Only if we can't read it. So.
Well, it's cut off because we needed to talk about 2A. So 2A, and I'll explain it in just a minute, is the new loan application. Okay, new loan application. Within blank business days of acceptance, buyer agrees to submit a completed loan application to a lender of buyer's choice, and 2, furnish a pre-approval letter to seller based upon a standard factual credit report and review of debt to income ratios. If buyer fails to complete any of these conditions with the applicable time frame, seller reserves the right to terminate the agreement. In such event, both parties agree to cancel the escrow and return the EMD to the buyer. Buyer shall use buyer's best efforts to obtain financing under terms and conditions outlined in this agreement. So let's take a few minutes and break this down. So, pre-approval letters. So a buyer gets to pick any lender they want to under RESPA, correct? We all say yes, right? Okay. Can a seller require a pre-approval letter from a lender of the seller's choice? Yes. Okay. That is allowable under RESPA. Okay. Just so in case that comes up. If they fail to do any of this, now the sentence, in such event, both parties agree to cancel the escrow and return EMD to buyer. Now, we put that language in the contract, and you're going to see it in multiple places. Now, whether or not your title companies are going to require additional documentation is a separate issue. The reason we put this language there is specifically designed that if the buyer and the seller ever have to sue each other, there's a concept in contract law known as the four corners doctrine, that everything that's related to the contract has to be within the four corners of the paper. So the reason why we write that sentence is, at the end of the day, if there's a breach of contract, who is the ultimate decision maker as to who's going to get the earnest money? Rhymes with mudge. Judge, right? The judge. So the judge is going to look at that, and we want to make sure that we have the party's intent in the document. The reason we also do that is so that it is not an issue of fact. Meaning, there are two things that are decided in a courtroom: issues of law and issues of fact. Issues of law are like, is this murder one versus manslaughter? Questions of fact are, was the light red or the light green? Judges decide issues of law. Juries decide issues of fact. There's a concept called a motion for summary judgment. And a motion for summary judgment is where you can go into a civil judge and say, Judge, we don't have to go to a jury because there are no questions of fact. There are only questions of law. And the reason we put this language in there, and you're going to see it in multiple places, is so that if you ever have your clients have to sue, they will not have to go to the expense of a jury trial, ideally. We can get them out on a motion for summary judgment, which is more efficient and cost saving. So that's why that language is there, if you're wondering. Any questions about the new loan application section, section 2A? Yes, ma'am. So the question is do you have an obligation as the agent to verify that the pre-qualification letter is based upon standard factual credit reports? The answer is no. This language is pretty common. You can't get a pre-qualification letter that isn't based on industry standards of credit ratios and debt ratios. We put that language in there, but I don't anticipate there's any kind of affirmative duty for you to verify that. If the pre-qual letter is acceptable to your client, that's really kind of the way it is. The lender has all the liability for making a representation that they're pre-qualified when they're not. So I don't think that there's any kind of obligation under NRS 645 or NAC 645 for you to verify that. Pre-qual, pre-approval letter, basically going to be the same. The language is here is just to say that whatever letter you provide is going to be based on the standards of the mortgage industry for pre-qualification or pre-approval. Okay? Any additional questions on section 2A? All right, let's move on to the sections that are going to have lots of questions. Let's talk about the appraisal contingency and the loan contingency. Section 2B. Buyer's obligation to purchase the property is contingent upon the property appraising for not less than the purchase price. If after the completion of an appraisal by a licensed appraiser, buyer receives a written notice from the lender or the appraiser that the property has appraised for less than the purchase price, a notice of appraised value, buyer may attempt to renegotiate or cancel the RPA by providing written notice to the seller with a copy of the appraisal no later than blank calendar days following the acceptance of the RPA, whereupon the EMD shall be released to the buyer without the requirement of written authorization from the seller. If this residential purchase agreement is not canceled in writing on or before the appraisal deadline, buyer shall be deemed to have waived the appraisal contingency. All right, so let's break this down. So first, obligation to have the property appraised to the purchase price. Okay? And there's a time frame of how long that has to take. I don't know what that number is. You guys do. okay? It's going to depend on your market. It's going to depend on a variety of factors. I can't tell you what that number is. I do know that the Nevada Mortgage Broker Association, when GLVR released these forms, came out with some recommended numbers, but that's your guys. That's the experts in real estate to be able to tell how long it's going to take to get an appraisal, okay? And this is a hard deadline. If you blow it, it's deemed to have been waived, okay? If you blow it, it's deemed to have been waived. So, what does that mean for you? If you pick a 35-day, and I just picked a number, I have no idea if that's a good number or not, a 35-day appraisal contingency, on day 30, if you're the buyer's agent, you'd better be in writing saying, where are we at? Do we need to get an extension? What's going on? So you got to be a little more proactive, which is why I love that checklist, so you're not surprised by this deadline, okay? Yes, ma'am. Okay. So her question was, we love the language that says the earnest money is supposed to be released without additional signatures, but title company won't do it. Do we have any title reps in the room before I rip on the title industry? Fantastic. Okay. So this has always been an interesting thing for me, and the lawyer in me understands why they do it. They don't want to get sued. They have the buyer and the buyer's attorneys, and particularly in your market, because let's be honest, if you can afford houses up here, you can probably afford to hire slimy guys like me to sue people. So they're threatening everyone. The buyer and the seller's attorneys are lawyering up. They're threatening to sue everybody. The title company says, we're not going to release anything until we get something in writing. Now, which I find very fascinating, because the purchase agreement actually sets forth that the title companies are supposed to, they take all their other instructions from this document and they say, well, the contract says this is what we're supposed to do, and we're supposed to be a neutral third party, except for the scenarios that it's not in our best interest, because that's really what this is. The contract clearly tells them they're supposed to do this, but they're acting in their own to protect themselves from alleged liability. And so I understand the breakdown there, but again, we want this language so that if you ever have to go to the Washoe County Courthouse and talk to one of the judges, that language is there. So you can point it to it and say, Judge, not only did the buyer and seller execute this document, their initials are at the bottom of each page, Your Honor. There's no issue of fact here. Everyone signed this. The only question, Judge, for you is there a breach of this contract? Because the damages and the liability has already been established. Now, that being said, we kind of want the title companies to kind of do a slow roll on this, because if they hold the funds and say we're gonna wait a little bit and make a decision based on signatures, we want them to do that because, does everybody understand the concept of the judicial action called interpleading the funds? Has anybody ever heard of that? Okay, so let me walk through what this is. It's for anybody. It can be anybody who has money that they're not sure who's entitled to. For example, I did a couple of foreclosures back in 2006 where there was actually the house sold for more than what the mortgage was. Well, the bank doesn't get to keep that. So interpleading the funds is a scenario where a title company or someone else has money and they go down to the courthouse and they say, Judge, we don't know who's supposed to have this money. Here are the people who all claim that they're entitled to it. Here's the money. We've noticed them. They can all come down and fight in front of you. The unfortunate part about that is under state statute, the title company can take all of their attorney's fees and costs off the top and you don't get to challenge it. So your $35,000 earnest money dispute becomes $62.38 after I get paid. Okay, that's a slight exaggeration. But my point is, they can do that. And we don't really want them to do that because I don't think that's really in the best interest of your clients. So I understand there's a little bit of opposing forces here with that language, but the idea is we tell the judge, and we'll talk about releasing of escrow and earnest money. We have a separate cancellation form that we'll talk about towards the end of the day. Any other questions about the appraisal contingency? Yes, sir. Okay, so the question is what do you have when you have multiple appraisals? And so the answer would be, the provision would still apply. The question would be, the purchase price is the purchase price. And so what happens if the appraisal doesn't, for example, the real scenario is if it comes in above, you've got a contract for the purchase price, and thanks for the built-in equity, ha ha ha, right? But if it comes below, that's where the issue becomes, because just because you have an appraisal that is below the purchase price, does that automatically mean, and I like nice round numbers because I went to law school, let's say the purchase price is $300,000. The appraisal comes back at 200 grand. Does that mean that the buyer is going to be able to buy the house for $200,000? No, you still have a contract where you've identified a purchase price. So you're going to do one of a few things. You're either going to cancel the agreement, you're either going to pay the purchase price, or you're going to work out some kind of agreement in between. That's really it. So this language just says the appraisal has to be done by a certain time. In your scenario where there's competing appraisals of different value, you would handle that the same way you always do, with either renegotiating a contract or terminating it and moving on. So the question is, what do you do if you waive the appraisal? If you're going to waive the appraisal, I would put NA in line 14. And then under section 28, which is the additional terms, I would say buyer and seller agree to waive the appraisal contingency as identified in section 2A. That's what I would do, okay? When we made this change in Las Vegas, section 2B and 2C were, and then we'll talk about due diligence in a section, those were the primary big changes. I want to make sure that we're all clear on this, because if you muck this up, as a buyer or seller's agent, the liability is all on you. I don't want to scare you, but at the same time, I want to scare you that the liability here is going to be on you. So are we all clear on section 2B? Yes, ma'am. So the question was, she thinks that it creates too much guesswork. And to be honest, there is a little bit, and I wouldn't say it's guesswork. I would say, I'll be honest with you. I'm an attorney. I bought a house. I wrote this. I hired a realtor because I don't know what that time frame is supposed to be. That's your job as the professional, as the real estate professional, to tell me what that time frame is. Yes, there's going to be some, there's going to be some delay. You have other people you have to rely on. That's the standard thing of any real estate transaction. We mirrored this language off of California and Utah's purchase agreements. So that's where it came from. Again, for the purposes of today, I certainly appreciate your feedback on what you don't like. I don't have the ability to fix that today. And since we're recording this, I'd like to really narrow our questions down to what it is. If you want to, again, that process of going through your forms committee of addressing changes, you could certainly do that. All right, let's go on to the loan contingency. Buyer's obligation to purchase the property is contingent upon buyer obtaining the loan referenced in section 1C or 1D of the RPA unless otherwise agreed in writing. Buyer shall remove the loan contingency in writing, attempt to renegotiate or cancel the RPA by providing written notice to the seller no later than blank calendar days following the date of acceptance of the RPA, whereupon the EMD shall be released to the buyer without the requirement of written authorization from seller. If this residential purchase agreement is not canceled in writing on or before the loan contingency deadline, buyer shall be deemed to have waived the loan contingency. Okay. Very similar to the appraisal. Again, certain time frame to be able to qualify for a loan. The scenarios we were seeing in Las Vegas was, buyer not getting the loan documents in, canceling day or two before close of escrow. Seller actually has real damages in that situation, particularly if they were moving out, if they were doing repairs, those kinds of things. So we wanted to make sure that there was a vehicle by which that the buyer knew that they had to act in good faith and secure that loan. And then it walks you through what your options are. You either remove it, attempt to renegotiate, or cancel the agreement. Any questions on that? Yes, ma'am. I would certainly not ever recommend an appraisal contingency of 10 days and a loan contingency of 5. I think you would have some serious problems there. You're absolutely correct. Now, what those dates need to be, that's you getting in touch with the loan company, that's you getting in touch with the appraisal, that's you being the real estate professional and identifying. But you're absolutely right. We've heard horror stories in Las Vegas of this scenario where they're not thinking through the time frames. Because if you need the appraisal to secure the loan, how can you have a longer appraisal contingency than a loan contingency? Again, I can't tell you what that date needs to be. That's going to depend on your market. That's going to depend on the appraisals. You guys will need to figure that out. Vegas, it varies. You guys are the experts in your market. I'm not even really comfortable saying what Vegas does because I don't want to influence you. That's what you guys do. Any other questions about the loan contingency section? Okay, section D is cash purchase. Within X number of business days, buyer agrees to provide written evidence from a bona fide financial institution of sufficient cash available to complete this purchase. If buyer does not submit the written evidence within the above period, seller reserves the right to terminate the agreement. Okay? Well, you would fill in, for example, earnest money, additional deposit. You would not fill in 1C because it's not contingent upon qualifying for a loan. 1D you wouldn't fill out. 1E you wouldn't fill out. F would be, because that would be the balance of the purchase price minus the earnest money, and G would be the total purchase price. So you would fill out some points of section 1. Okay? So the buyer has an affirmative obligation within however time frame you have to turn those things over. If the seller doesn't, the seller reserves the right to terminate. Now, why a seller would wait till the close of escrow to terminate if they don't have proof of funds, that's a different thing. But we just, so, you know, you certainly could. And there are, I hate to use the word parachute, but there are means by which both the buyer and the seller can legitimately terminate this agreement in several places. But you're right, there isn't a specific time frame the seller to decide they want to do that. There might be a scenario where I don't want to cancel the contract. Okay, you can't prove that you've got $38 million in cash, but you might be able to go get a loan. So rather than canceling the agreement, if I would be amenable to that, we would just simply amend the contract to reflect that it's not going to be a cash deal. Okay, there was another hand. Well, yeah, you would, for example, if it's a cash purchase
So
on NA,
okay, that's what.
which you would want to do anyway, even if it was a conventional loan, if you're picking 1C, you would do not applicable on D and E. And I can tell you that I have not heard that as a complaint in Las Vegas in the 3 years we've been with Incident and the 3 years this form's been live. So I'm assuming that means it can, because no one has stormed my office with pitchforks and torches. So. Any other questions so far? Okay, contingent upon sale of the other property, we have a standalone form that walks through the contingency that identifies that. We'll talk about that, but if the property is contingent upon a sale of another property, you mark yes, and it's the formatting here is a little bit wonky, but you would mark it is not or it is. If it is contingent, then you'll pull the contingent upon sale addendum, which we'll talk about at the end once we go through the entire RPA. One thing that I have noticed is this has come up in Las Vegas in several multi-million-dollar properties. The MLS photos had, and this, they literally went to court over this. MLS photos had a picture of a very nice chandelier in the MLS. They did not address it in the additional terms. They didn't address what was going to happen to the chandelier. Buyer wanted it, assumed because it was part of the advertising that it was part of the sale. Seller took said $150,000 chandelier, and 3 years later they went to a jury trial over that. So what I would do if I were you is I would sit down with my clients and make sure that if there's any kind of personal property that is not going, because what they did is there was an argument that it's not in the contract, but the counter argument on the buyer was fraudulent inducement to contract. You committed fraud because you took this picture of the chandelier. It induced me to buy the property. It's the only reason why I wanted that house.
No.
This is the argument they took to jury. I'm just saying, 3 years later, after litigation, if I loved that picture, that Velvet Elvis, so much that I fell in love with that $20 million house, you could make the argument. And the problem is it's fraud. So it's a tort-based claim, right? Which means you can get punitive damages, which means you can get attorney's fees and interest. They also sued the agents because you knew that this chandelier was not going to be transferred, but you took pictures and you put it and took the affirmative steps to put it in the MLS.
But the painted Elvis was not a fixture, and that leads you to a question about furniture.
So what I would say is when you have the scenario where when you're taking your photographs in the MLS, you may want to not take pictures of things that may or may not transfer, or be very clear in the agent-to-agent remarks. Because this happened, I didn't make this up. So there was litigation over a 6-figure chandelier. They settled right before the jury came back with a jury verdict, which basically means both sides were terrified, so they quickly settled right then, after 3 years of litigation. So I can't tell you who won because there's a confidentiality agreement. So to avoid that scenario, just be mindful of that, okay? Well, so the question is a light fixture a fixture, right? A legal fixture. That's a very good question. I mean, the situation was the seller took it, had no intent to keep it, buyer expected it to be there. There was a lack of to go all Paul Newman on you, there was a failure to communicate. And so that was the scenario because they just, and I don't think the agents were incompetent. I just think that they had not thought this scenario through. And unfortunately, they paid yes, they settled on the steps of the courthouse, but 3 years of litigation is not cheap. So,
No,
yes, ma'am.
what you're
Your
saying-
advertising photos, you need to be mindful of what your advertising photos say. Because if, for example, the seller has no desire, they have a very unique piece of art, they have no desire for that to stay, or a unique thing in the furniture or whatever, just be mindful of that. At couches, I think you're probably going to be okay, but the light fixture was enough for them to litigate. So, I want to get through section 5 and then let's take our first break because we've been going at about an hour. So let's talk about escrow. Escrow, so the first thing, section 5A, purchase of the property shall be consummated through escrow. Opening of escrow shall take place at the end, again, 1 business day after acceptance. So if you are accepting an offer at 3 o'clock in the morning, escrow's got to be open by 5 p.m. that same day. I'm not suggesting that you shouldn't work hard and do late nights. I just think you may be mindful of when you trigger acceptance because of that unique situation with timeframes and the way that Nevada defines business days. It gives you a place to identify the escrow company with the escrow officer. Opening of escrow shall occur upon escrow company's receipt of this fully accepted agreement. Escrow holder is instructed to notify the parties through their representative agents of the opening date and the escrow number, excuse me. Any questions about that? Pretty standard language? Okay. Earnest money, 5B. Upon acceptance, buyer's EMD as shown in section 1A and 1B if applicable of this agreement shall be deposited pursuant to the language in section 1A and 1B if applicable, okay? So earnest money, additional deposits. Really quickly, because we get this often in Las Vegas, maybe you guys are ahead of the curve on this. Can you have a valid contract without earnest money? Yes. Okay. Offer, acceptance, consideration is what you have to have, right? So it is possible that you can have a valid contract and not have earnest money. So do you want to wait because we have this scenario sometimes happen in Las Vegas where they say we want to wait to open escrow until we've received the earnest money. You have a valid contract. If they don't if they don't deposit the earnest money, it's a breach of the contract. It doesn't mean the contract doesn't exist. And as we talk about liquidated damages a little bit later on, we'll explain why that is an important separation between the two because of the way we limit the amount of damages both the buyer and the seller can have in the contract. Okay. So it's hard to see, but the first line is the close of escrow date. It's the top of page 3. This is where you actually identify the close of escrow. D is the IRS 1031. The IRS disclosure. Seller is hereby made aware that there is a regulation that requires all escrow holders to complete a modified 1099 form based upon the specific information known only between the parties in this transaction and the escrow holder. Seller is also made aware that escrow holder is required by federal law to provide this information to the Internal Revenue Service after close of escrow in a manner prescribed by federal law. Standard disclosure, shouldn't be anything unusual for you. Got a good question on the break about wall-mounted televisions as a part of the fixture section. It's a very good question. I'll take it back to our forms committee and have them take a look at it, but it's a good idea. If the wall-mounted television or the wall mounts themselves, you may want to identify that in section 4 as well. Okay, so we are in title insurance, section 6 on page 3. This purchase agreement is contingent upon the seller's ability to deliver good and marketable title as evidenced by a policy of title insurance, naming buyer as the insured in the amount equal to the purchase price, furnished by the title company identified in section 5A. Said policy shall be in the form necessary to effectuate marketable title or its equivalent and shall be paid for under section 8A. We'll get to 8A, but 8A is basically where we walk through who pays for what, okay? Any questions about this? Pretty standard language. We went with generic here because we used to, the one in Las Vegas used to specifically identify the specific title policy. And the concern that I had with that is, as realtors, as long as you guys stay within the boundaries of your license, under NRS 645, you're protected. And the concern was, if you're making a specific recommendation of a specific title policy, while you may have a lot of knowledge about that, you're not in the title industry. So we wanted to make sure that we let the title people explain the different types of title insurance, and all we really want to do is make sure that we have fair and marketable title, okay? Let's talk about Section 7, due diligence. This is, we're going to spend a lot of time on this section right now. So Section 7 starts off with buyer's obligation is or is not conditioned on the buyer's due diligence as defined in this Section 7A below. This condition is referred to as the due diligence condition. If checked in the affirmative, Sections 7A through C shall apply. Otherwise, they do not. So if you have a situation where you have the transaction where you are not going to have a due diligence period, if you're going to waive it, you would mark is not, and you would skip A through C, okay? If it is conditioned on a due diligence, inspections, all that fun stuff, we'll talk about it there. Buyer shall have X number of calendar days following the date of acceptance, as defined in Section 23. Again, Section 23 is the definition section, to complete buyer's due diligence. Seller agrees to cooperate with buyer's due diligence. Seller shall ensure that all necessary utilities, gas, power, and water, and all operable pilot lights are on for buyer's investigations and through the close of escrow. Okay? Questions so far? All right, let's jump into the inspection condition, which is Section 7A. During the due diligence period, buyer shall take such action as buyer deems necessary to determine whether the property is satisfactory to the buyer, including but not limited to whether the property is insurable to the buyer's satisfactions, whether there are unsatisfactory conditions surrounding or otherwise affecting the property, such as locations of flood zones, airport noise, noxious fumes or odors. The phrase you really wanted to hear on a Thursday, right? Noxious fumes and odors. Environmental substances or hazards, whether the property is properly zoned, locality of freeways, railroads, places of worship, schools, golf courses, etc. Take a minute and I want to talk about golf courses. I don't know if this is happening up in this part of the world, but it is happening in Las Vegas and across the country. The redevelopment of golf courses into residential housing. Is this happening up here? Okay, so let's take a few minutes to talk about it. In Las Vegas, we have a big one called the Badlands Golf Course. It is surrounded by some of the most expensive houses in Las Vegas. A person came in, wants to close the golf course and redevelop the entire property. There are currently 10 lawsuits involving this development, 3 against the city, one of which claiming that the Las Vegas City Council is anti-Semitic. I'm not kidding. And so there's 10 lawsuits going on. And the reason we wanted to put this here in the due diligence provision is because there is at least 5 golf courses going through conversion in Las Vegas. And the problem is how that conversion is going to work and whether it's going to be successful is highly fact-based. It's going to really depend on a couple situations. For example, there's one golf course that wants to redevelop that it is part of the HOA, part of the CC&Rs, that the homeowners association must run a golf course. That scenario, I think the buyers or the homeowners are probably going to win because it's a covenant running with the land. There's one golf course that has a deed restriction where they agreed contractually in the deed with the local municipality that the property would only be run as a golf course for a certain period of time. And then there's that one that has 10 lawsuits that there's no zoning restrictions, there's no nothing. Las Vegas attempted to come up with restrictions on how to develop this thing. Those are 3 of the lawsuits. So I don't know the answer. And more importantly, I don't want to make you become experts on this major issue because each state's handling it different. And unfortunately, I think this is something that's not going to go away. So the idea of putting it in the due diligence section is for you to have a conversation with your buyer client. Look, if you want to have that amazing view on a golf course, that's important to you, you really need to verify the financial stability of the golf course because that is really outside the scope of your professional abilities. I'll be honest with you, I don't even think I could give you an answer because I'd have to dig out each a golf course's individual operating procedures. There might be deed restrictions, there's going to be zoning issues, and that's way outside your scope, and that's just a lawsuit waiting to happen. So if that's an issue for your golf course clients, I think having that conversation with them that unfortunately, and I know, so on top of those 3 I just talked about, there's 6 others in Las Vegas that are currently doing this as well. And unfortunately, because for a variety of reasons, including the lack of interest in golf, in some age demographics. I think there's too many golf courses, particularly in Las Vegas. I think we've got about 60 in GOAR's area. So just to be mindful, if this is an issue, I don't think it's going away. Ideally, the legislature will address this like they did in Texas and Florida, where there's notice restrictions, notice requirements to the owners, those kinds of things. But as of right now in Nevada, there really isn't a unified structure. I don't think there's even anything here or in Reno. So you'd have to be very careful about that, because the last thing we want to do is have you get sued because you put somebody on a multi-million-dollar property and then the golf course closes down because it's just not financially viable. This language should protect you if that scenario comes up. Okay. During such a period, buyers shall have the right to conduct non-invasive, non-destructive inspections of all structural, roofing, mechanical, electrical, plumbing, heating and air conditionings, water, well, septic, pool, spa, survey, square footage, and any other property or systems through licensed and bonded contractors or other qualified professionals. Seller agrees to provide reasonable access to the property to buyer and buyer's inspectors. Buyer agrees to indemnify and hold seller harmless with respect to any injuries suffered by buyer or third parties present at buyer's request while on seller's property conducting such inspections, okay? So basically, if the buyer comes in and his inspector hurts themselves while they're doing a roof inspection, the seller's not going to be liable for that, the buyer will be, okay? Let's see. Buyer's indemnity shall not apply to injuries suffered by buyer or third parties present at the buyer's request as a result of an intentional tort, gross negligent, or any misconduct by omission by seller. I apologize, we have to throw that sentence in. You need to blame the Nevada Supreme Court. The Nevada Supreme Court over the last decade has taken these types of language, which is an indemnification language, and has specifically stated over a series of about 5 or 6 cases that indemnification language has to be very specifically drafted or it is void. So this isn't my fault, blame Carson City. As a side note, if you have independent contractor agreements, if you have team agreements, if you haven't taken a look at those in the last 4 to 5 years with your indemnification language, I strongly urge you to go find a Nevada licensed attorney and have them take a look at that, because the landscape has changed on the legal aspect. Not necessarily that your existing contracts are bad, but the courts are taking a harder look at that. And the last thing you want to do is have indemnification language that you're relying on, and then have the Supreme Court come back and say, this is not specific enough, okay? Okay. Buyers are advised to consult with appropriate professionals regarding the neighborhood or property conditions, including but not limited to schools, proximity and adequacy of law enforcement, proximity to commercial, industrial, or agricultural activities, crime statistics, fire protection, other government services, existing and proposed transportation, construction and development, noise or odor from any source, and other nuisances, hazards, or circumstances. If buyer cancels this agreement due to a specific inspection report, buyer shall provide seller at the time of cancellation with a copy of the report containing the name, address, and telephone number of the inspector. The reason why we put this language in is, again, we don't want you to feel like you have the obligation to go out and inspect every type of property. And this typically comes up with crime statistics, because the problem you have with crime statistics is if somebody asks you about crime statistics, you have a two-edged sword there. You have the scenario that if you disclose crime statistics, you could possibly be sued by the seller for disparaging the title, which is a tort-based claim. The other one that always comes up is this point is, do you have to disclose if somebody died in a property? No, it's not material. Okay, so, but to kind of walk through what is a scenario of something that could be material, I had a conversation with one of the attorney generals who are with the real estate division. We were talking about what is relevant and material to a real estate transaction, and she told me the following story. And she lives in a high, really expensive subdivision in Las Vegas called Queens Ridge. Well, Queens Ridge has an infestation of wild bunnies. Okay? If I'm the buyer and I come, wild bunnies, okay, fuzzy bunnies. So if I was a buyer and I came to you and said, what's your name?
Marianne.
Marianne, I have something embarrassing to tell you about the property I'm going to buy. I have a phobia of fuzzy bunnies. They terrify me. I will not buy a home where there's an infestation of fuzzy bunnies. Will you please verify with the seller that there is not an infestation of fuzzy bunnies in Queensridge? And you communicate that to the seller. Guess what? That fuzzy bunny infestation has now become material and relevant because I asked about it. So be mindful of the fuzzy bunnies. In Las Vegas, we have the language about the odor because in North Las Vegas, there used to be a 400-acre pig farm. That if you were downwind of the 400-acre pig farm, it was not a place you wanted to be. So that language is there, but I think you're right. For example, I have celiac disease. I am allergic to gluten and to wheat. I could not live in a home that was downwind of a wheat factory. That would be something that I would have to verify as a part of due diligence and cancel because of my existing medical condition. So while I don't think there are very many wheat flour factories in Las Vegas or in Incline, but that would be a scenario that I think that I could cancel because of an external situation. Okay? If buyer determines in buyer's sole discretion that the results of the due diligence are unacceptable, buyer may either 1. No later than the due diligence deadline referenced in Section 7, cancel the residential purchase agreement by providing written notice to the seller, whereupon the earnest money deposit referenced in Section 1A shall be released to the buyer without the requirement of further authorization from seller, or 2. No later than the due diligence deadline referenced in Section 7, resolve in writing with seller any objections buyer has arising from buyer's due diligence. So basically request for repairs. Now, we'll talk about, because we have a separate request for repair form, but just to make sure that this section says that they have to resolve in writing their objections. So if I come in with a 35-page list of repairs, the seller just has to agree to make those repairs within this section. The repairs don't have to be done within that period, okay? Just to make sure that's clear. This is just the parties agreeing that they're going to do this, okay? All right, 7C. If buyer fails to cancel the RPA or fails to resolve in writing with seller any objections buyer has arising from due diligence, buyer shall deem to have waived. So in your scenario, let's say due diligence ends tomorrow. Now this is kind of an interesting scenario, we'll walk through it. If the seller hasn't responded and due diligence ends tomorrow, that's your answer. So let's be clear on this. You as licensees under NRS 645, you have an obligation to communicate with your opposing counterpart, not opposition, your counterpart. I, as the seller, legally, you can't make me respond to your request for repairs. And I'll have to. You can't make me. What are you gonna do, sue me? So I, as the seller, your recalcitrant seller, I don't have to respond to the buyer's request for repairs. You as a licensee under NRS 645, you have to pick up the phone or send an email and say, that Sanders guy is kind of a jerk, he's not responding. Don't call your clients jerks, just as a side note, it's just a description. But you would need to say, my seller is not going to respond. So you can comply with your obligations under NRS 645, but legally you can't make me respond to your request. Okay? So silence in that situation is your answer. So the question, that situation is what happens if the seller wants to give a credit or the seller wants to find out how much the repairs are going to cost. Under this section, you have to resolve in writing those objections before the end of the due diligence period. So if the seller wants to go through and see how much these repairs are going to cost and the close of escrow is tomorrow, you would need an extension. Okay, seller, I'll give you the time to do that, but we're going to extend this 10 days, 15 days, however long it takes them to do that research. So you would want to do that because if you get past that date, the way that it's written, buyer is deemed to waive that 35-page repair request. Okay? Yes, sir. Okay. So the question is, if you're going to cancel the purchase agreement, do you have to give a reason? And I'll address that in 2 ways. One, we have a form that we'll talk about later on today that walks through the cancellation that actually makes you reference a specific section. But there could be a variety of reasons. Legally, all I have to do is buyer say buyer hereby cancels the agreement. That's enough. If you came to me as your private attorney and said, I want to, cancel my agreement with my sign vendor, I would probably just do 3 sentences that says, pursuant to, we terminate the agreement X number of days out from today. It doesn't have to be War and Peace. It can be 3 or 4 sentences. But it's going to depend. If it's because the seller is failed to disclose that they've been burying weapons-grade uranium in the backyard, you may want that additional information if you're going to sue. So it's going to be a fact-based scenario based on the reasons why you're canceling, but a sentence or 2 would be sufficient. So if the seller doesn't respond, okay, let's do it this way. Seller doesn't respond, and close of escrow is at 11 o'clock on November 8th. At 11:01, what happens pursuant to this language? Buyer waives it, and we're moving forward to close of escrow. Okay? So if the seller doesn't respond, silence is your answer. That means no, I'm not going to do it. And so then your buyer will have to make the decision before this time frame ends. Is this the dream house? Am I willing to waive my 35-page repairs because this is the house I want to raise my children in? Or if they're not going to respond and fix the stuff, is it time for me to cancel and go find another house with a seller that actually would fix things? Okay, so let's read the beginning of that sentence. If buyer canceled this agreement due to a specific inspection report. So we put that condition in there. If I'm canceling because my asbestos investigator says this thing is nothing full of asbestos, or it's full of black mold-like substance that it's unsafe to say, if I'm canceling because of that, the contract, this is a contractual term, that the parties agree they're going to turn that over. But if I'm canceling just because I don't like the house, you arguably don't have to. It's only that specific situation if there's a specific report. This is the reason for cancellation, okay? So the question was, why don't you have to have a reason? You don't have to. I can breach a contract. You can cancel any contract for any reason. Now, there may be penalties for that, but I can do that. So I don't have to give you a reason. You can't make me. So do I think it's a good idea if you have a valid reason to explain it? Yes, it certainly mitigates the possibility for litigation down the road. Is it a legal requirement? No, it is not. Just like if there's a death in the property, you don't legally have to disclose it, but let's be honest, as soon as they talk to the neighbors, they're going to find out. I would probably have the conversation with my client about maybe just preempting that and talking about it, but you don't have to. So the question of whether or not a seller is entitled to earnest money when the buyer cancels the contract is a legal question. And the answer is it's going to depend on the facts behind it, and if they're going to sue, I can't answer that question. There's a possibility, yes. There are scenarios where both the buyer would be entitled to all of it, seller would be entitled to all of it, but that's a breach of contract lawsuit that would be highly fact-based based on your scenario. So yes, but there's not a specific. You guys love bright yes/no answers, and this situation of who's entitled to earnest money is going to be based on the facts and whether or not they decide to sue over it. And the problem you guys have is at some point, an earnest money dispute becomes a breach of contract lawsuit, and you are not attorneys. And the unlawful practice of law in the state of Nevada is a misdemeanor. So I would be really careful that when you get down that road that you're definitely sending the email to the client saying, I am not an attorney. If you want to proceed with a lawsuit, you need to talk to somebody. I'm more than happy to help you out, however that works, but I can't give you advice on who's going to win or who's going to be entitled to that. Be very careful about that. So the question is this a breach of contract? What I'm saying is there's one of 3 things that happens in a real estate transaction. Successful real estate transaction, right? Buyer sells, buyer buys the property. Parties terminate the contract and are happy and go on their way. Or it's a breach in the general sense, and it's a potential lawsuit. Those are the 3 options. And so what I'm just saying is as you get closer to 2 and 3, you just need to be careful because that's starting to get outside of the scope of a real estate license and turning more into a legal issue. And unfortunately, the definition of practicing law in the state of Nevada is advising any individual on any right and on any issue that impacts any legal right. Please tell me how everyone in the state of Nevada doesn't practice law every day. And the people who are going to decide whether or not you're practicing law without a license is a bunch of lawyers. So I would love to give you a bright line on this, but the language in the Supreme Court opinion is intentionally vague, and it's going to be highly specific. So just be careful of that.
Yes, let's remember that this is not about the contract. This is frivolous conversation, unfortunately, so.
Okay, we're going to move. Okay, so we've talked about this before under 2B and 2C. That language about it should be released directly to the buyer is designed for a judge if they litigate. I understand that title companies may require additional documentation, but that sentence is not designed for the title company. It is designed for the judge down at the courthouse. Ideally, they would. And don't get me wrong, I'd love to take a class action lawsuit against every title company in Nevada and sue them over this because I think they lose, but you know, that's not my day job. So you're right that that's a conflict, but the idea is to tell the judge what you want so that we can avoid legal costs if you have to sue. So, inspections will be acceptance offers subject to the following reserved right. Buyer may have the property inspected and select the licensed contractors, certified building inspectors, and or other qualified professionals who will inspect the property. Seller will ensure that the necessary utilities are turned on and supplied to the property within 2 business days after acceptance of this agreement to remain on until close of escrow. It is strongly recommended that buyer retain licensed Nevada professionals to conduct inspections. That's designed to protect you, so that if the buyer comes back and, because I don't know if any of you have had interactions with the Nevada Contractors Board, but they are extremely aggressive and go after parties who use unlicensed contractors on a regular basis, and there's actual criminal sanctions. So we put this in here because we had a scenario where we had a couple of realtors get in a whole lot of trouble in front of the Contractors Board. So this language is there so that the buyer and the seller are on their own if they decide to choose unlicensed professionals. Okay. If any inspection is not completed and requested repairs are not delivered to seller within the due diligence period, buyer is deemed to have waived the right to that inspection, and seller's liability for the cost of all repairs that inspection would have reasonably identified had it been conducted, except as otherwise provided by law. So the idea with this language is that if the buyer doesn't conduct, for example, a mold inspection, and then after close of escrow discovers all kinds of mold, they've waived the right to sue the seller here. So the buyer really needs to make sure they're conducting all the necessary inspections during this period. It's designed to, and also to protect the agents involved in the transaction as well. Any questions about 7D? Yes, ma'am. So the question is, typically I have a list of people that, of professionals that I give to my clients. In your scenario, if you are making a list of professionals that you're giving to the seller and they are not licensed contractors under state law and state statute, there is significant liability for you in that situation. Okay, and the Contractors Board is extremely aggressive. I would, whether or not you want to have the business decision of having a list of professionals, that's your call. If you're going to do it, you'd better make sure they're licensed, because you can be held responsible for that. Because I'll be honest with you, the first thing I would do if I was the buyer and I got dragged down in front of the Contractors Board is I would throw you under the bus. And you're a professional. I relied upon your real estate professions, and I assumed that these were all licensed professionals under state law and in compliance, and you have a tough argument because you put that list together. So yes, I would say in that situation you'd better make sure they're all licensed and all that fun stuff. Now, do you have to verify they've ever been sued and gone through bankruptcy and what's the name of their second-born child? No. But verifying they're a licensed contractor, you can go to the Nevada Contractors Board's website and pull that information relatively easily. Okay. Let's talk about this next section, and this actually, I can't tell you how excited this table makes me. Really, I know I have no life, but our previous document, this used to be an entire page of check boxes, right? And I remember thinking to myself, my gosh, it's the 21st century. Can't transaction desk just do a drop-down menu? So that's what this is. That's what this little guy right here is. It's going to drop down and click buyer, seller, See? Buyer, seller, 50-50 waive, not applicable. And in your filling this out, it will not allow you to go past these without putting an answer in there. Okay? So we like shaved 3 pages off of our contract just by doing this. So these are drop-down menus that you'll be able to identify which party pays for what. Yes, sir.
Yeah, so what if you were actually filling out a contract in handwriting? Where would you find these drop-downs?
You wouldn't. And so what you did, if you're old school, want to do it pen, we tell seller, buyer, 50-50 waive or NA right there, and you would have to write it in each one. But this document is designed to be executed electronically through the computer system. Now you can do that if you want to. There's enough space for you to write it in. But it's designed to do this through the drop-down menus. Yes. And yes, I'm a nerd that a table made me so very, very happy. If you're a broker, again, this will help you. So it would be, you're absolutely right, it's on the buyer, but there would be certain situations where who pays for certain inspections is a negotiable term between the buyer and the seller. It's quite common in Southern Nevada for that to occur, so we gave the parties the ability to negotiate that here. If the seller doesn't want to pay for any of those inspections, they could certainly say no. Okay, so the question is, at the time the offer is presented, if the buyer wants to, for example, have a septic inspection, they mark that they want to have a septic inspection and a septic pumping, and then they find later on that the property is connected to the sewer system and that's not necessary, for example. You could certainly, the lawyer in me, would probably say it's best to put in writing that you're waiving that. Just so that there's no issues. Because the first thing that your grumpy buyer does when they come to my office to look to sue you and the seller, the first thing I start doing is looking for holes, looking for places that you didn't dot all your I's and cross all your T's, and I could make a lot out of that. I would get in the habit of doing that, not only because I think it's good business, but it also helps me that if you ever get sued and I'm your attorney, I can put you up on the stand and say, isn't it true that it is your pattern and practice to, in writing, waive every inspection that we don't need? Isn't it, and you would say yes, isn't it your pattern and practice that you have that conversation with your client, and isn't the email identified as Exhibit 75B that email? That's a much better argument than, well, we didn't really need it, so we just didn't do it. It's cleaner. And I would also talk to your broker, because your broker may have an internal office policy on that, but the lawyer in me would highly recommend that you do all that in writing. Okay. So you're misunderstanding her question. The question would be, so instead of waiving it here, they wrote, they want a home and they want a septic lid removal and they want the seller to pay for it. That's in the contract. But later on, they change their mind after the contract has been accepted. You would probably need to address that in writing after the fact. Her question was after the contract had been accepted. So it's not the scenario that they waive it when the offer is presented. It's the scenario where they demanded a specific inspection, and then during the due diligence period, they changed their mind. And how do you address that in the contract? Because we went with device, because it could be possibly it could be stove, it could be a fireplace, it could be that kind of thing. It's a device, so it's far more general than, because I could make the argument that it's not a stove, it's a fireplace, so I don't have to inspect it. But a wood burning device addresses anything that burns wood that's part of the property. And if you're unsure, you could always just write it in under the other and identify it that way, okay? Honestly, that's actually a really good question. Let me tell you why we don't have any section where the agent will pay for something in this contract. Because we don't want the agents to appear to be a party or to have some sort of third-party beneficiary. And we've had litigation in Las Vegas over scenarios like that where an agent paid for things and then they sued arguing that they had the duties of an owner, particularly in property management. So we've taken a very, very conscientious point to try to reduce your amount of liability as the agents. So we try not to put you in a situation where you can get sued over that though. If you want to pay for that on the back end, You could certainly do that as a business decision, but that would be a separate agreement between you and your client, and not to try to muddy the definitions of parties to the purchase agreement. I'm suggesting, because I'm cheap, that I don't want to pay for anything.
Well, yeah, well, that goes without saying.
So, well, look, whether or not you as a real estate professional decide you're going to pay for certain things is an individual business decision you will have to make with your own broker. The reason why we took it out of the contract and didn't even make it an option is we had the scenario in Las Vegas where an agent was paying for certain inspections. And then the contract ended, and the seller sued the agent because of the payment. For example, if there's if you pay for an inspection and the inspector is injured because you're paying for it, there's potential liability there. So we wanted to limit the amount of liability this document creates for the real estate professionals involved. And if there's liability for anything arising from the contract, it should stay with the parties to the contract, who are the buyer and the seller, and not you guys. Yes. All right, so section E, in the event of an inspection reveals areas of concern, buyer reserves the right to require a certification. The expenses for certification will be paid outside of escrow unless the parties present instructions to the contrary prior to the close of escrow. So basically what we wanted to do is give the buyer, if they felt that they needed additional investigation or certifications, give them the right to do that, but make it flexible enough that if you didn't need it, it wouldn't muck up the contract. So the way this contract is written is the parties could negotiate that, but it will be handled separately. So you could do it if you wanted to do it that way. The buyer could pay for it. You could ask the seller to pay for it. This gives you the flexibility to do either way. Let's talk about the next one, request for repairs. It is the buyer's responsibility to inspect the property sufficiently as to satisfy buyer's use. Buyer reserves the right to request repairs based upon the seller's real property disclosure, or items which materially affect value or use of the property revealed by an inspection, certification, or appraisal. Items of a general maintenance or cosmetic nature which do not materially affect value or use of the property which existed at the time of acceptance, which are not expressly addressed in this agreement, are deemed accepted by the buyer except as otherwise provided in this agreement. The brokers herein have no responsibility to assist in the payment of any repair, correction, or deferred maintenance on the property which may have been revealed by the above inspections agreed upon by the buyer and seller or requested by one party. Really quickly, since we just want to take a quick second on the SRPD, since we just mentioned it, and this is an issue down south, I don't know if this is an issue here, where you get a seller, a flipper, who wants the buyer to waive the acceptance of the SRPD. Does that happen here? Okay, so really quickly, you can't waive the requirement to have an SRPD. You can be really dumb and waive your right to all remedies under the SRPD. So the seller has to produce that document. What the buyer can do, and I don't know why you would, the buyer can waive their ability to sue the seller for stuff they didn't disclose. Why you would want to do that, I have no idea, but that's what you can waive under the SRPD, okay? All right, let's move on to section 8. Fees and prorations. So again, we're going to identifying who pays for what, title policy, title owner's policy, appraisal, escrow fees, transfer tax, and then 8B. Any and all rents, taxes, interest, homeowner association fees, trash service fees, payments on bonds, SIDs, lids, and assessments assumed by the buyer and other expenses of the property shall be prorated as the date of the recordation of the deed. Security deposits, advance rentals, or considerations involving future lease credits shall be credited to the buyer. All prorations will be based on a 30-day month and will be calculated as of the close of escrow. Prorations will be based upon figures available at closing. Any supplementals or adjustments that occur after the close of escrow will be handled by the parties outside of escrow. So basically what we did with this provision is anything out there is going to be prorated. If you don't want to prorate it, you need to address it in additional terms. It's after 8A, so it's seller, buyer, 50-50, waived or not applicable. You don't know what SIDs and lids are? Okay, maybe that's a Las Vegas thing. SIDs and lids are where a developer, where a developer goes in and builds, for example, in Summerlin in Las Vegas. They go in and they put in the infrastructure for roads, those kinds of things, and they bond them. And they're called a SID and lid, and they're allowable by state law. So basically, when the city of Las Vegas doesn't pay for those streets in the new construction. The developer does, bonds it, and then the people who are in the homeowners have to pay that money back. So it's a special assessment, SID and LID. So it's kind of like an HOA fee, but it's designed for those things. If you guys don't have them, we could talk about removing them from the language. So the question was, is you guys have language in your document that the seller can cap the amount of damages. We have a standalone request for repair form that addresses all of those costs related to the repairs. Preliminary title report. Within 10 business days of opening of escrow, title company shall provide buyer with the preliminary title report to review, which must be approved or rejected within 5 business days of receipt thereof. If buyer does not object to the preliminary title report within the period specified above, the preliminary title report shall be deemed accepted. If buyer makes an objection to any item contained in the title report, seller shall have 5 business days after receipt of objections to correct or address them. If within the time frame seller fails to have such exception removed or to correct, buyer shall have the option to either terminate, elect to accept title, or elect to accept title as is. Lender and closing fees. In addition to seller's expenses identified herein, seller will contribute blank to buyer's lender's fees and or title and escrow fees, excluding or excluding costs which seller must pay pursuant to loan program requirements. Different loan types have different appraisal and financing requirements which will affect the parties' rights and costs under this agreement. Home protection plan. Buyer and seller acknowledge that they have been made aware of home protection plans that provide coverage to the buyer after close of escrow. Buyer waives or requires a home protection plan with blank. Seller or buyer will pay for home protection plan at a price not to exceed amount. Buyer will order home protection plan. Neither seller nor brokers make any representation as to the extent of coverage or deductibles of such plans. Well, so you could certainly do that. The other way you could do it is you could write in half of price here. You could do that. You could do it in the additional terms. If that's language that you want, again, we can certainly update the form, but we don't have that ability to split it in Las Vegas. But you could certainly put it in additional terms. Transfer of title. Upon close of escrow, buyer shall tender to seller the agreed upon purchase price, and seller shall tender to buyer marketable title to the property free of all encumbrances other than current real property taxes, covenants, conditions, and restrictions and related restrictions, zoning or master plan restrictions and public utility easements, and obligations, assumes, and encumbrances accepted by the buyer prior to the close of escrow. Buyers advise the property may be reassessed after close of escrow, which may result in a real property tax increase or decrease. Common interest communities. Yay! Okay, CICs. We got to go through this section and talk about a couple of things because there are requirements in Section 10. If you don't have an HOA or a CIC, this isn't applicable, of course. But if the property is sold in one, we've got to go through this because there's a couple of sections here that are required by statute. There are a couple of sections that are contractual that you could amend, and we need to go through that. So the first thing I need to tell you, and I love your creativity, but you cannot contractually get out of statutory obligations. I'm going to say that again. You cannot contractually agree to waive statutory obligations. Because if that was true, there would be an envelope around my car where the speed limit is always 120 miles an hour. Trust me, the Nevada Highway Patrol does not take that position. So you cannot, for example, you and I cannot decide that heroin is legal and shoot up in front of the police. We don't get to do that, okay? So if it's in statute, you can't waive it. If it's contractual, you can amend it. And there's certain parts in here that are required by state statute that you can't waive. And there's other things that are not. So the first thing, let's go through Section 10. If the property is subject to a common interest community, seller shall provide at seller's expense the CIC documents as required by NRS 116-4109. The seller must provide these. The resale package, and they must pay for it. Now, to answer our question to our friend in the back, whether or not the seller's agent could pay for it, that's a separate issue. But by statute, the seller cannot require the buyer to pay for the resale package, okay? Next sentence, seller shall request the resale package within 2 business days of acceptance and provide the same to buyer within 1 business days of seller's receipt thereof. This is a contractual term, meaning For example, if you're worried that the property is not going to appraise to the purchase price, you could amend this language that the seller will request the resale package within 2 business days after the appraisal, if that's an issue. So that sentence you can change. Seller still has to pay for it, but when it is ordered in the time frame of the transaction is a contractual obligation that the parties can amend, including the receipt. Now let's talk about the receipt of this package, because this is something that comes up in Vegas, and I doubt it comes up here because you guys are really respectable and mindful professionals who don't have these kinds of issues. But if I drop the resale package off at your office and it sits at your receptionist for 2 days, and then you get it to your client, how many days does the client have to review the CIC package? Those 2 days you blew, okay? 5 total. It's not 5 from when you give it to them. It's 5 from when I deliver it to your office, okay? This always comes up when the buyer wants to cancel. And if it sat at your receptionist for 2 days and you blows the 5-day window, guess who I'm gonna sue, okay? So be mindful of that. Now, if I'm delivering these, I would have you want to have proof. So I'm a big fan of hand delivery of this stuff, unless you can prove emails. So if you're going to hand deliver it, you create a very simple document. It's called receipt of copy. I do it in Microsoft Word. You could do it in Google Docs. It literally just says receipt of copy on blank day. I hereby acknowledge receipt of the resale package. And then I make 2 copies of it. And I have the receptionist sign them both. They keep one, I have one. I now have proof of that 5-day window. That's what I do in my law practice when I have to provide proof of service. You could do emails are okay. The problem with emails is verifying they were actually read, because I can turn off the read receipt and the delivery receipt. I don't have to respond to that. So be mindful of that. Text messages, I'm not a fan of doing, I know you guys love the text. I am not a fan of doing anything related to a real estate transaction via text, and here's why. And we're going to slightly deviate, and she's going to be mad, but we're going to talk about this because I think it's important. So when you text, in order for me as your attorney, because as a side note, does anybody know what the statute of limitations for breach of contract is in the state of Nevada? 6 years. 6 years. Please tell me what you were doing on November 8th, 2012 at 11:25 a.m. Okay? So you want to write this stuff down. Now, in order for me as an attorney to submit documents into evidence, I have to lay what's called an evidentiary foundation. Now, lawyers are paid by the syllable, so evidentiary foundation is like a second boat for me. So it's good stuff. But my point is I have to verify it. So I have to verify the document's accurate, that it's not forged, it was written on the day it was presented, it was kept in the ordinary course of your business. So emails are great. They've got a date. They've got a time. Is this your email address? Yes. Is this the seller's email address? Yes. Letters are even better. Sent via US mail. That's good stuff. Text messages are really hard, because how are you going to prove to me you sent a text? You're going to take screenshots, right? There's no date. There's no time. Why on God's green earth you decided to name the opposing agent as Big Bad Wolf in your contact information makes it very, very difficult for me to lay an evidentiary foundation that this is an actual business discussion. I am not saying that you shouldn't text. I have a 15-year-old daughter. I totally get it. But what I'm saying is, I would follow that up with a confirmation email, or by the software that converts your text messages into emails, so you've got that saved for that statute of limitations, okay? And then it's much better it is when I put you on the stand and we're verifying the email, and I would say, isn't it your pattern and practice that in addition to this email, you send a text message confirming that they got the email? Yes, much better if you have, now let's be honest, we don't want you to end up in the courthouse. But if you do, we want to make it as easy and as possible so that it doesn't turn into a popularity contest. Who does the jury like more? You or the other person? Who's more sympathetic? We want them to be able to, based on the documentation, and we want to paper your file because that's going to protect you. So there's my rant on text messages. Feel free to text me afterwards and I'll share more about it. Kidding. So let's go back to here. So pursuant to NRS 116.4109, buyer may cancel this agreement without penalty until midnight of the 5th calendar day following the date of receipt of the resale package. If buyer elects to cancel this agreement pursuant to the statute, he or she must deliver. This is a recent change, by the way, to the statute, 2017. Via hand delivery, prepaid U.S. mail, or electronic transmission. This was added less than a year ago, electronic transmission. It used to be you had to hand deliver or U.S. mail, which was a lawsuit waiting to happen because none of you did that. You all just sent emails. So thank your Nevada Association of Realtors for getting that added to the statute, okay? Electronic transmission. And now please note that I can also send it to the authorized agent, okay? So this only becomes an issue when it was delivered, when I'm canceling on day 5. So, best practices. If you have a situation where there's CIC package and you're into that 5-day window, on day 3, you probably should be contacting your buyer and saying, if there are issues, we need to address them sooner rather than later, because the 5th day is always going to be a problem, okay? Now, it also used to be that you could cancel it via midnight on the 5th day, but you could only deliver it by a hand delivery or U.S. mail. So how do you cancel something up until midnight when you have to deliver it or mail it, right? So that's a nice update. If the buyer does not receive, so this one here, this is statutory. You can't change this. This second bullet point is contractual. And we're going to talk about the pros and cons of this right now. Somebody mentioned a parachute. If you want the biggest parachute of the contract, it's this one. If buyer does not receive the resale package within 15 calendar days of acceptance, this agreement may be canceled in full by buyer without penalty. There is no restriction on that. So if the seller does not provide the resale, if they don't get it within 15 days after acceptance, it's a get out of jail free card up until 4:59 p.m. on close of escrow. They can cancel for any reason. So if you are a seller's agent, be very mindful of this one right here, okay? Now this is contractual. You could waive it. You could say, we don't want lines 29 through 31 on section 10. But keep in mind, this does not expire. So like the due diligence, your loan contingency, the appraisal contingency, if the buyer doesn't do something within that window, it goes away. This one stays open. Okay, so if you're a seller's agent, be very careful of this. Yes, ma'am. Okay, so the question is, and I know it's hard to believe, so HOAs take their sweet time turning these resale packages over, right? And they charge outrageous numbers, and they're kind of jerks about it, because, let's be honest, they're people who work for an HOA, so they're miserable. Oh, great, this is going to be on the internet. Fantastic. The question is the HOA, so there's a couple parts of NRS 116-4109. And by the way, if you want a cure for insomnia, read NRS 116. It'll put you to sleep. So there's 2 parts. There's the time frame that that the HOA has once the seller gets the request. Once the seller says, hey, I need a resale package, the HOA has a certain period of time by statute that they can take to get that, and they take the whole time. That is not what any of this is talking about. And so but you're right that it comes in on this section right here. So the question becomes, the HOA is taking their sweet time getting the documentation. We are dangerously close to this 15 days, because if, for example, the seller waits and doesn't order the resale package because they don't want to. The hot property's been on the market for 3 or 4 times. They've bought 3 resale packages. They don't understand why they can't just use the one they got 6 weeks ago. All that kind of fun stuff. So they wait. And they wait until day 6 after acceptance, okay? The HOA has how many days? 10. 10 business days. Please. So even if it's 10 calendar days. So on day 6, I order it. 16 days. They take their sweet time. We've now breached this, which means the buyer can get out anytime they want to. So to answer your question, if the HOA is taking their sweet time, I would definitely consider addressing this.
So you can do it.
Yes, you can. This one's contractual. You can amend this. This one, and thanks for pointing out how short I am. This one is statutory. Yes, ma'am. Yeah, we got what we had in Las Vegas is we had a lot of problems where sellers were saying, I don't have to do this. agents would say, we're gonna make the buyer pay for it. So we just decided to end all of that, put it in bold, and tell you the statute says you must do this. Because then it's cleaner for you if you're the seller's agent, because the seller's upset they have to do this. Gosh, I'm really sorry, but I can't break Nevada law for you. The law says you have to do it. I'm sorry, and this is the way it is. Upon such written cancellation, buyer shall promptly receive a refund of the EMD. Parties agree to execute any documents requested by the escrow holder to facilitate refund. If written cancellation is not received within the specified time period, the resale package will be deemed approved. Seller shall pay outstanding CIC fines and penalties at the close of escrow. Okay. Again, if you have HOAs, this is something you've got to really be mindful and on top of, because I see a lot of potential liability for the agents not timely responding because it's a really tight window for response times. In the back, yes ma'am. So her question was, some of the HOAs up here have a first right of refusal. Or, for example, the situation we're seeing in Southern Nevada is the HOAs have a rental restriction, or they preclude short-term rentals, and it's buried in the CIC package. The answer for you as a licensed real estate professional is, by state statute, the buyer has 5 days to review it. If they have questions of what that document is, they would need to talk to an attorney within that 5-day window. This is by statute, so you can't change the time frames. And you really want to be careful about going outside the scope and telling your clients what the CIC package says. I have a story about that. Maybe we should wait till Kendra leaves so we don't get in trouble. But it's a scary story, and it involves Las Vegas, so of course it's a little salacious. So here we go. Before I came to the association, I was in private practice in real estate, and I represented a client who wanted to open an Adam and Eve adult novelty store. Okay? That business model is highly regulated by both the state, and where you can put those types of businesses is highly regulated. Okay? And so she got the franchise agreement, and the franchise agreement said, look, you really need to go talk to a commercial real estate professional and an attorney as to where you can put your Adam and Eve franchise. So she hired a commercial realtor. The commercial realtor found her, and this is 2007, so really at the bottom of the market, right? So they found her a place in Las Vegas off of the Tropicana and the 215 Beltway. 7-year commercial lease, $15 million, a lot of money. And as you know, for those commercial practitioners in the room, you sign a commercial lease, you're on the hook for the whole thing. So before she signed, she said to the agent, are you sure that I can put my business here? He, instead of saying, gosh, I'm not an expert on zoning on adult novelty stores, you should probably go find somebody, he went down to the county, to the zoning department. And the zoning department said, yep, there are no zoning restrictions about putting that business at that, 200 yards away from a preschool. You can put that business right in there, no problems whatsoever. So my client signed the lease, then went down to the city of Las Vegas to get a business license. The business license department said, are you nuts? There's a preschool 200 feet away. We don't let these types of businesses anywhere near this. And it's been like this for 50 years. You got to go down to the streets called industrial. You got to go down to industrial to put that place in. So then she had this problem. She went back to the landlord and said, they won't let me put my business in here. Landlord said, gosh, that's a really sob story, but I don't care. So she came to me. This is before my time with the realtors. So guess what we did? We assigned our rights to sue the real estate agent to the developer, to the landlord. My client walked away with no liability whatsoever. That agent paid a high 6, low 7-figure number to settle that case. All because they went outside the scope of their license and said, yep, you can put your business here. Yep, there's no problems with the CIC package. There's no right of first refusal. There's no rental restrictions whatsoever. When you stay within the confines of NRS 645, you are protected. Once you go beyond that, you're staring at a 6 to 7-figure liability number. That was after 3 years of litigation, by the way. So, moral of the story, make sure you stay within your license. So if your client has questions about unique language in the CIC, I'm not an HOA attorney. I have no idea. Unfortunately, the statute says you have 5 days, and I would be writing this, I would be putting this in writing. I wouldn't just do it as a phone call, or if you do it as a phone call, confirm it. If you've got any questions about anything in that CIC package, by statute, you have 5 days. You really need to go talk to an attorney. Best of luck. Let me know what I can do to help. And that's it, okay? Now that I've scared you all to death, because it's quiet in here, do you have any questions about these 3 bullet points before we get down to CIC related expenses? Okay? All right, CIC related expenses. Aside from what we just say up there, the seller has to pay for the resale package, there are other types of fees, contributions, if your HOAs are anything like they are in Southern Nevada, they are highly creative in whatever they call these things, these fees, transfers. So we tried to be vague here rather than creating like a 95-page HOA addendum where we identify each HOA's individual costs. So this is designed to be like this. Any questions on those related expenses? We put everything related to the HOA in one section so that if you're lucky and you don't have to deal with an HOA, you don't have to fill it in. The resale package by state law is required to be paid there, but there are other HOAs that in Southern Nevada charge a demand fee that's separate from the resale package. So we put these things in there. If they don't apply, you would just put not applicable. But for example, there are transfer fees. And I can tell you at least 15 different ways that HOAs in Las Vegas identify that. So we try to be vague. So you're going to have an idea of what those HOA fees and costs are going to be based on when the HOA tells you of all that. And then you can figure out who pays for it or how to identify them. But we didn't want to make this too specific. Let's talk about my favorite disclosure in all of the earth, the open range disclosure. Okay, so disclosures, SRPD, open range, construction defect claims, lead-based paint, and other. Now, we went with other. You might have an internal office where you do all kinds of disclosures in your office. You may require all those. That's where you put them. What we don't do, if you'll notice this is intentional, there is no language that says that these disclosures are incorporated into the contract. Okay, we did that on purpose because what we were seeing in Southern Nevada is we were seeing short sale lenders looking at this entire section and saying, we demand to see all of these. And they were refusing to approve the short sale until they apparently wanted to look at the open range disclosure or the other issues. So we made this so that you could make the argument to the lender. They're required by statute. They're not contractually incorporated into the contract. And hopefully the market never gets back to the place where we have a lot of short sales again, but that's why that language, which normally would be included here, you would want to include it in the contract. We did it intentionally because we just found it was mucking up the short sale approval process because it's not like that thing happens really quickly anyway. Okay, Federal Fair Housing Compliance and Disclosures. Any questions on that? Walkthrough. Buyer is entitled under this agreement to walk through the property within blank calendar days prior to close of escrow to ensure the property and all major systems, appliances, heating, cooling, plumbing, and electrical systems and mechanical fixtures are as stated in the seller's real property disclosure statement, and that the property and improvements are in the same general condition as to when this agreement was accepted by seller and buyer. To facilitate buyer's walkthrough, seller is responsible for keeping all necessary utilities on, including operable pilot lights. If any systems cannot be checked by buyer on walkthrough due to non-access or no power, gas, water, then buyer reserves the right to hold the seller responsible for defects which could not be detected on walkthrough because of the lack of such access. The purpose of the walkthrough is to confirm A, the property is being maintained, B, repairs if any have been completed as agreed, and C, sellers comply with seller's other obligations. If buyer elects not to conduct a walkthrough inspection prior to close of escrow, then all systems, items, and aspects of the property are deemed satisfactory, and the buyer releases seller's liability for any cost of repair that would have reasonably been identified by a walkthrough inspection except as otherwise provided by law. We have a separate walkthrough form we'll get to in a minute, but this language here is designed to protect you. You didn't tell me that if I waived my right that there might be problems. Any questions on this? We'll probably have more when we get to the actual walkthrough form, but let's move on. Delivery of possession. Seller shall deliver the property along with any keys, alarm codes, garage door opener controls, and freely transferable parking permits and gate responders outside of escrow upon close of escrow. Seller agrees to vacate the property and leave the property in a neat and orderly, broom clean condition and tender possession no later than close of escrow or if there's another date. In the event seller does not vacate the property by this time, seller shall be considered a trespasser in addition to buyer's other legal and equitable remedies. Any personal property left on the property after the date indicated in this section shall be considered abandoned by the seller. Do I think that you would be able to call the Washoe County Sheriff and have somebody removed for trespass? Probably not. It's designed to be a little bit of intimidation. Most likely, if the seller refuses to vacate, you're going to bring an unlawful detainer action through the Justice Court. Which is the only venue as required by by the state constitution. That's probably a 30 to 45 day process. If it's an eviction, there's a requirement, or if it's an unlawful detainer action, there's requirements to hold property with a certain period of time if it's an eviction or a foreclosure, and that case law is incredibly terrifying. This is not an eviction or a foreclosure. This is a transfer of property, and this sentence is sufficient for the purposes of a real estate sale. But if you're a property manager, you definitely don't want to follow this sentence because the case law in Nevada on valuation of that property, if you, for example, we had a couple scenarios where eviction companies went in and trashed out the wrong unit. They're supposed to go to 221, they went to 222, trashed out the whole place. And they didn't keep it. They're supposed to hold it for a certain period of time. They didn't. They just trashed it, threw it all away. Now, this is the case law in Nevada. It is that the buyer, the party whose property is destroyed, is the only one that gets to present a calculation of value. So this pen is not a $3 pen. This is a pen that I used with the incredible realtors in Incline Village, that if I had to put a value on this, it would be $65,000. I know, bargain. Feel free to see me afterwards if you want to buy it. But the other side's attorney can't go, that's ridiculous, it's a $3 pen. They don't get to do that. The $65,000 is the only amount that gets to go to the jury. So if you do property management, make sure that you follow the time frame, and I believe it's 14 days. Don't quote me on that. It's been a while since I looked at the statute. But for the purposes of our discussion related to the residential purchase agreement, this language is sufficient. Okay? Next section. It's this little innocuous paragraph that you don't think is a big deal until it explodes, and it's a huge deal. Risk of loss. Risk of loss shall be governed by Nevada Revised Statute 113.040. This law provides generally that if all or any material part of the property is destroyed before transfer of legal title or possession, seller cannot enforce the agreement, and buyer is entitled to recover any portion of the sales price paid. If legal title or possession has transferred, risk of loss shall shift to the buyer. This is, if it ever comes up in your life, I feel sorry for you right now. Really, it's, you know, the house burns down while it's in escrow, or it's struck by lightning, or there's a flood, those kinds of things. This becomes particularly dicey when you have holdovers, when you have a seller who wants to stay, okay? Or a buyer who's already in the property, particularly dicey. Unfortunately, we don't have time today to talk about possession before or after the close of escrow. We do have some forms on that. If it's something that you're concerned about, please see me on the break. I'll give you a few minutes, and then the next time I come up, we'll go over all those rest of those forms. But risk of loss, NRS 113.040. Assignment. Unless otherwise agreed, the contract is not assignable. It's a standard provision in contracts. If you want to have the ability to assign the contract, you'll need to put it in additional terms. Don't think that's a big issue. It doesn't usually come up, but there you go. Section 17. Let's talk about cancellation. And we're going to spend a lot of time talking about this because there's a lot of things that could go wrong and moving around here. In the event this agreement is properly canceled in accordance with the terms contained herein, then buyer will be entitled to a refund of the earnest money deposit. Neither buyer nor seller will be reimbursed for any expenses incurred in conjunction with due diligence, inspections, appraisals, or other matters pertaining to this transaction and otherwise provided herein or except as otherwise provided by law. Standard cancellation. The next thing we're going to talk about is the mediation provision. Before any legal action is taken to enforce any term or condition under this agreement, the parties agree to engage in mediation. Mediation fees, if any, shall be divided equally among the parties involved. Notwithstanding the foregoing, In the event the buyer finds it necessary to file a claim for specific performance, this section shall not apply. Each party is encouraged to have an independent lawyer of their choice review this mediation provision before agreeing thereto. By initialing below, the parties confirm they have read, understood this section, and voluntarily agree to the provisions thereof. So we'll talk a little bit about specific performance in a minute. We also want to talk a little bit about mediation. 2 years ago, if you would have come to me and said mediation provisions, I'd be like, we can still go down to the courthouse, the Washoe County Courthouse. We can file what's called a lawsuit called declaration relief, where we want the judge to declare that our contract is valid, and then they'll order us to go to mediation. And that's exactly what a heavy machinery company did in Reno. They had a franchisee in Alaska who breached the contract, wasn't buying the heavy tractor equipment. They had a provision very similar to this in their contract. And the Reno guys said, gosh, Alaska, we really should mediate. Wouldn't it be great if we mediate? We should probably mediate, but never formally said, we hereby invoke the mediation provision. So then they did what I just suggested. They went down to the Washoe County Courthouse and they filed a declarative action. Well, Alaska rolls in and goes, what are we doing here? Why are you suing us? We have this mediation provision. It says we have to go to mediate before anybody brings a lawsuit. That went all the way to the Nevada Supreme Court. And for time-wise, that's about 6, maybe 7 years. And the Nevada Supreme Court came down and dramatically changed the legal landscape and said, nope, Reno, mediation provisions are what's called a condition precedent to litigation. Again, lawyers get paid by the syllable. It's a fancy way of saying you got to mediate before you can litigate. So, not only did Reno lose their lawsuit, but to punish them for not executing the mediation provision, they ordered them to pay the other side's attorney's fees to the tune of like 200. So not only did they have to pay to the tune of like 250 grand, then they had to go back and mediate because they hadn't even resolved their dispute. That is controlling case law in the state of Nevada, meaning that this mediation provision, or if you have any contract, not just real estate, any contract that you have a mediation provision, it means a whole lot more. So the reason that we have initials is to verify that the buyer and seller really understand that they are doing mediation and they have to mediate before they can go to a lawsuit. Now, what does it mean if buyer initials but seller does not? They didn't agree. Now, if I'm the agent, I'm calling the other side and saying, was that did you just miss that? Or did you intentionally waive the mediation provision? Now, you still have a valid contract, but your client's going to need to decide whether or not they want to proceed without mediation, because mediation is extremely it's much more cost effective. It just means chances are that the only person who's going to reject the mediation provision is a guy like me, right? An attorney or a client who's got an attorney who says we don't want to do this, we want to be able to sue, okay? Now, the mediation provision does not apply. Now, it also says that the parties get to pick their mediator. Those are standard language, so it's standard mediation language, but for the purposes of your contract, we wanted to make sure that the parties really understood what they were agreeing to, because I'll be honest, if I'm selling my house and the other side won't agree to mediation, that's going to maybe impact my decision to sell to them, because I don't know if that means I don't want that risk, right? That's a decision that's going to be there because I'll get you in just a minute, because the landscape has changed. So this is not a contractual change, like we came up with new language. This is the Supreme Court saying this has changed. It is now a requirement. Yes, ma'am. That means that the parties haven't agreed to mediate. It means you have a valid contract, you just don't have a valid mediation provision. Okay? And then the client who wants to mediate will have to decide whether or not they want to move forward with the transaction, knowing that litigation is probably going to be the desired vehicle to resolve any disputes rather than, mediation. Yes, sir. His question is, what happens if the buyer agrees to mediate, sends a contract over, seller executes it, but doesn't initial the mediation provision? So you do have a valid contract, but they've rejected the mediation provision. Well, technically, if they didn't execute it and they sent it back to you, it would be technically, let me think of this, probably more a counteroffer than a valid contract because they're rejecting a specific term. So it would be a counteroffer in that sense, which would why I would want to pick up the phone and say, hey, did you just, did your client just skip this initial? Because that happens all the time. They don't initial everything. Or did they do this intentionally? But because Nevada law now requires an arbitration provision to include the following phrase, the parties hereby agree to waive their constitutional right to a jury trial, and everyone would flip out. I don't want to waive any constitutional rights. So he took the provision out because it was causing such problems. So he left the mediation with the ability to litigate. But you're right, it is a little confusing, and I'm monitoring it, and I'm trying to find the best way to balance those two. Let's talk specific performance. So specific performance is the remedy where the seller refuses to sell, so the buyer can go down and sue and order them to sell the house. Now, it's a very rare remedy. We don't usually require people to do things. If your landscaper breaches the contract and doesn't come and mow your grass, you typically can't get an order ordering them to mow your lawn forever. You usually get money. But we view real property to be special, so it is a unique remedy. It's there, but most of the time, unless your client's got cash, chances are specific performance is a threat that is most likely not going to happen. Because personal injury lawyers, there's a reason why personal injury lawyers don't advertise on TV for specific performance. You're gonna need to pay me up front. I'm gonna need certified funds. And best case scenario to go to trial on a pretty regular specific performance case, it's gonna be $65,000 to $85,000 up front, just for my attorney's fees. And you also have to be able to specifically perform, right? You can't just have a mortgage, for example, because you can't specifically perform because you have a condition that has to be required. So it's in there, it has the ability if they really want to sue. It's only going to primarily come up with, it's very rare. I've been practicing law for 17 years. I've never seen a successful specific performance case. It's possible, it's just very, very rare. Specific performance is primarily where the buyer sues the seller just to get the house. So we'll talk about seller defaults. If the seller defaults in performance under this agreement, buyer reserves all right and or equitable rights against seller, and buyer may seek to recover buyer's actual damages incurred by buyer due to seller's default. So so this is where it gets complicated for you as a real estate professional. Explaining language that says what they're going to get when they win a lawsuit is what? Got to be really careful on this one. So I would say this is the section if you've got any questions on what your possibilities are, what your remedies would be if you go to court, you really need to speak to an attorney. Because they reserve all their rights and they can attempt to recover actual damages incurred. So they can if the seller breaches, but again, that's going to be a highly fact-based scenario. If that situation ever comes up, this is more of a reservation of rights rather than an explanation of what's going to happen. It means the buyer has the right to do this. They still have to go find an attorney, have a valid case, all that fun stuff. Okay? 18C, if buyer defaults in performance of this agreement as seller's sole, this is a liquidated damages provision. As seller's sole legal recourse, seller may retain as liquidated damages the earnest money deposit. In this respect, the parties agree that the seller's actual damages would be difficult to measure and that the earnest money deposit is in fact a reasonable estimate of the damages that seller would suffer as a result of buyer's default. Seller understands that any additional deposit is not considered part of the EMD in section 1B herein and will be released by escrow holder to buyer. So, liquidated damages provision. Basically, seller's remedies are limited to the earnest money deposit. Can a seller refuse to agree to this? Yes. What does that tell you about the seller? They're a guy like me, or they have a few of me on retainer. And that be something that your buyer may want to consider whether or not, because at this point, if the buyer breaches, it's just limited to the earnest money. If we waive that, I can come after you for $1.8 million worth of compensatory damages, right? Or whatever they are. So, yes, a party can waive this section. When they counteroffer it back, that would be something that you would definitely want to recommend that your client consider talking to an attorney about, because this is designed to protect the buyer. And if they waived it, I know if I was a buyer, I don't know if I would want to proceed with that transaction. But I'm also paranoid and, So 19 is escrow instructions. Any questions on that? Pretty standard stuff. 20 is unclaimed funds. So in the event that there are any funds held over, they're going to be deemed abandoned pursuant to section 120A of NRS. So basically, if the escrow holder holds funds for an extended period of time and they comply with statute and means to be abandoned, that they will turn them over to pursuant to statute, which means it goes eventually to the Department of Taxation. I don't think this has ever really happened in real life, but we need the language in there anyway, just in case the buyer and seller both decide that they don't really need that earnest money and it sits at the escrow company. Okay, 21. Broker compensation and fees. Buyer herein requires and seller agrees as a condition of this agreement that the seller will pay a listing broker and buyer's broker who become by this clause a third.
Back.
All right. Apparently we don't want to talk about compensation. You guys do this for free. As a condition, third-party beneficiary to this agreement that certain sum and other percentage of the purchase price commission that seller and seller's broker offered for the procurement of ready, willing, and able buyer via the multiple listing service or any advertisement or written offer. Seller understands and agrees that if seller defaults hereunder, buyer's broker as a third-party beneficiary of this agreement has the right to pursue all legal recourse against the seller for any commission due. In addition to any amount due to buyer's broker from seller or seller's broker, buyer will or will not pay buyer's additional compensation, an amount to be determined between the buyer and buyer's broker. Okay. Pretty standard language. Any questions on that? Okay, waiver of all claims. Buyer and seller agree that they are not relying upon any representations made by brokers or broker's agent. Buyer acknowledges that at close of escrow, the property will be sold as is, where is, without any representations or warranties unless expressly stated herein. Buyer agrees to satisfy himself or herself as to the condition of the property prior to the close of escrow. Buyer acknowledges that any statements of acreage or square footage by brokers are simply estimates, and buyer agrees to make such measurements as buyer deems necessary to ascertain actual acreage or square footage. Buyer waives all claims against brokers or their agents for defects in the property, inaccurate estimates of acreage or square footage, environmental waste or hazards on the property, the fact that the property may be in a flood zone, the property's proximity to freeways, airports, or other nuisances, the zoning of the property, tax consequences, or factors related to the buyer's failure to conduct walkthroughs or inspections. Buyer assumes full responsibility for the foregoing and agrees to conduct such tests, walkthrough inspections, and research as buyer deems necessary. In any event, broker's liability is limited under any and all circumstances to the amount of the brokerage commission fee received in this transaction. So this is designed to protect you if anyone sues you. It's designed to say, not only do we cap the damages, but you're not a party. Pretty standard lawyer language. Section 23 is the definition section. It is rather long. I have no desire to tell you what all of these mean, but in a contract, when you see a word that is capitalized, for example, we capitalize buyer and seller, it means it's a defined term in the contract. So this is where the sections identify what different terms are: CIC capitalization, delivered, EMD, FHA, IVR, all that kind of good stuff. Yes, calendar days begin at midnight, business days begin at 9 a.m. Okay, business days are defined by state statute. Okay. So that's why when we talked about, opening escrow being a business day, because of that definition by statute, that's where it gets a little tricky, okay? All right, let's talk about signatures, delivery, and notices. This agreement may be signed by the parties on more than one copy, which when taken together, each signed copy shall be read as one complete form. This agreement may be signed by the parties manually or digitally. Facsimile signatures may be accepted as original. Standard language about multiple executions, incorporating them into one document. When a party wishes to provide notice as required in this agreement, such notice shall be sent regular mail, postal delivery, overnight delivery, by facsimile and/or electronic transmission to the agent for that party. The notification shall be effective when postmarked, received, fax, delivery confirmed, or read receipt confirmed in the case of email. Delivery of all instruments or documents associated with this agreement shall be delivered to the agent, for seller or buyer if represented. Any cancellation notices shall be contemporaneously delivered to escrow in the same manner. Standard delivery language that's pretty much in every contract. 1031 exchange is section 25. Other essential terms. So this is basically what lawyers call boilerplate. So we throw in the time of the essence language. We say that the parties can't agree to, they have to amend. If the contract is going to be amended, it has to be signed by both parties. It's binding on heirs, beneficiaries, and devisees. It's intended to be performed in the state of Nevada under Nevada law, and they agree to litigate in the county where the property is located. And then there's also a prevailing party attorney's fees section at the last section. 27, is there a question? Okay. Addendums, if you want to identify them there under 27. 28 is additional terms. Let's talk about the acknowledgement of offer saying language. So confirmation of representation. This buyer licensee disclosure of interest. This is where you identify under NRS 645 if you have an interest in the property. The real estate division requested, the commissioners requested that we put this language right here. So we did. So this is where, for example, if you're selling your own house, you would identify that interest. Okay, and we flipped it because most of the time you're going to mark that you don't have an interest, so we put that first. But if you do have an interest, there's this language here. Time at which the seller has to respond or the agreement's canceled. Let's go to the next page. Seller's response. Again, confirmation of representation. Seller licensee disclosure, same thing. And then the 6 letters that I never thought would haunt me more than anything else, FIRPTA. Yes, ma'am. Okay, so the question is the contract will self-expire if the seller doesn't respond within a certain period of time. So let's say that was yesterday, but then you get a response from the seller today saying we'd really like to accept. Technically, that's a counteroffer because the original agreement is dead. But as long as the parties both agree in writing, I don't think that would be an issue. I don't think you have to write an entirely new contract. Actually, take that back because I'm an attorney. I think you have to write another contract and you have to hire an attorney to do so. And I'm going to need non-sequential 20s in a brown paper bag. No, I don't think you have to do that. If the parties agree, they would. Now, what you would have to be careful about is just making sure that dates and things like that. There's no issues with that. But I think you could certainly agree to accept those terms if the parties are in agreement. I don't think a new contract is necessary. Now, if it's a highly complex matter, if you've got really, really demanding clients or it's a $80 million house, you may want to for protection purposes, but legally I think you could probably get away with an acceptance. So let's talk about FIRPTA. FIRPTA. Yeah, my favorite. Okay, does everybody understand FIRPTA? Yes? No? Okay. So, fun things about FIRPTA. So again, so FIRPTA applies, it's the Foreign Investment and Real Property Tax Act. It applies if the seller, for definition purposes, is considered a non-resident alien or a foreign corporation. Please note, foreign corporation is not a corporation based in a foreign country. It's based on ownership. So if you have a Nevada limited liability corporation that is owned with a certain percentage by folks who are non-resident alien individuals, FIRPTA may apply. So when the seller identifies that FIRPTA applies, aside from the fact that you've got to find a title company that's actually willing to jump through all these hoops, there are some exceptions to FIRPTA based on price point and whether or not the property is going to be used as a primary residence. So if FIRPTA is an issue, I highly recommend you find a title company and attorney who's well versed in this, because if the withholdings are not accurate, then the buyer has to pay the taxes that the seller should have paid. I don't know how much FIRPTA is an issue up here. It's a big issue in Southern Nevada with foreign investors in the property. So if FIRPTA is an issue, your time frames may take a little bit longer because it will require additional paperwork for the title company to comply. And all that fun stuff. So the first thing is that you need to know is you never want to be a FIRPTA designee. So basically what happens is so in the 1980s, there were a lot of foreign investors in American property, and they were not paying the federal income taxes because they would go back to the country they were from, and the IRS be outside of IRS enforcement. So they changed this law. This has been on the books since the 1980s. Thank Ronald Reagan for this. That basically when it's if the seller is and the term is non-resident alien individual, that they have to hold an estimate of how much that federal income tax will be. And if they don't hold that, the buyer gets to pay the seller's taxes. Okay? So the designee is the person, the buyer says, you're going to hold this money. So the statute says it can be anyone. So technically you could do it. Real estate agents can be. Why you would do it, you'd be absolutely nuts. But you could. It's going to be the title company. Now, you also have to find a title company that's willing to do it, because not very many are. So if this comes up, you need to find the title company, because there's sanctions. There's some exclusions. For example, depending on if they have a green card, chances are that FIRPTA doesn't apply. If it's a primary residence for less than $300,000, it may not apply. But it's messy, and this is the first step. Okay? It's not necessarily U.S. citizenship. It's the phrase in the statute is non-resident alien individual. Well, for example, if I have a green card, FIRPTA doesn't apply. If I have a tax ID from the IRS, even though I am not a U.S. citizen, FIRPTA may not apply. So it's not just necessarily, are you a U.S. citizen? Yes, no. It's a little more nuanced than that. FIRPTA is a big mess. I would definitely, if you have foreign nationals that are clients, sellers or buyers, you probably need to have them speak to a title company or an attorney or an accountant that's an expert in this stuff. I am not a FIRPTA expert. So, acceptance, counteroffer, rejection. The Realtor Code of Ethics and the MLS model rules were recently updated last week at the National Associations Convention in Boston. Very excited. So now it's a violation of so they've updated the language that says that if a buyer's agent asks in writing to the seller's agent, please confirm that my offer was presented and rejected, that they have an obligation under the code to respond to you in writing. Now, does that mean that the seller they have to send you a copy of the seller writing rejected over your agreement? No. But you can ask them to send a writing, an email, or a letter that said, I presented the offer to my client has rejected yours. So that's a recent change. So the question was, can you verify, yes, I understand that you're telling me the offer was rejected. Can you please verify it was presented to your client? And the Code of Ethics has been changed where you can specifically ask for verification that they presented the offer even if it was rejected. We are finished. Okay. So we're going to break for lunch here in a few minutes, and then we're going to go over all of the other documents we talked about as going through the RPA. We're a little ahead of schedule, but I want to make sure that we have some Q&A right now about the RPA before we break for lunch. So is there any questions about this document before we move on to like the request for repairs and things like that? Yes, ma'am. So the question is if the earnest money is returned, does the escrow holder have to hold or give any funds to the seller? And the answer to that would be the escrow holder has to do what the parties tell them to do. So if the seller says, I'm entitled to $5,000 or the $15,000 of earnest money, and the buyer says no, they're not going to release anything, and they're going to say go down to court and fight it out. So if the parties agreed to that, and they both sent, and we'll talk about that form this afternoon, they could certainly do some kind of agreement where they say seller is entitled to this amount, buyer is entitled to that. But the escrow holder, because they're a third party, they're supposed to have obligations to both parties. They really just can't unilaterally decide to give funds to one party or the other. The escrow holder doesn't get to decide whether or not the seller is entitled to reimbursement of those things. The parties would have to agree. If the parties don't agree, they'd have to go and fight it out in front of the judge. Okay? So the answer is, escrow holder doesn't get to decide that on their own. They're not a judge. Okay? Yes, ma'am. So the question is your existing contract has language where the parties can decide what the liquidated damages are going to be. Here's my concern with that. Who are they going to ask what that number should be?
Oh, it's written in the contract. contract.
It's written in the contract.
No, the number isn't, Lynn.
The number
You're
isn't.
You're the one that would be recommending.
So
it.
who would be recommending what my liquidated damages would be? The agent. What is that? Unauthorized practice of law without a license. I wouldn't be comfortable telling you what a liquidated damages cap would be unless you signed a retainer agreement with me and I was your personal attorney. You're literally saying to a buyer, this is the amount you will ever get if you go to a lawsuit, and you're not an attorney. If they feel like that number is too low, they're going to sue you, and you really don't have a defense. So I think that we could probably look at maybe giving more flexibility to your liquidated damages provision? Yes. Am I more worried about making sure that we don't put you in a place where you're practicing law without a license? Yeah. So that's the downside of the way you currently have it, is it's a ticking time bomb of liability. So you could do it in a lot of different ways. Like the California does a 3%. You could put it in there. We capped it at the earnest money because it's a hard number that's decided by the parties. The concern that I have with a blank is figuring out what that number is supposed to be, because that really, if you came to me as an attorney and said, we're entering into $1 million contract, there's a liquidated damages provision, what should those damages be? That's an assessment of risk and liability that I would probably have to write out against my professional malpractice insurance to give you a legal opinion as to what that's supposed to be. So I wouldn't be comfortable doing that as an attorney without some safeguards to protect me on the back end. So I am hesitant to put you guys in a place where you could be really sued over that. So.